Hi there, how are you doing today? My name is Conrad Mutiaba, and basically today we're going to be looking at the offense of manslaughter. And quite many times, manslaughter is confused with murder. So we're going to be looking at this offense, we'll define it, we'll look at the law, we'll look at the ingredients of the offense, and then we'll also proceed to look at the classes of manslaughter. And then, as a bonus at the end, I'll also help you to understand the scope of what actually amounts to causing death under the law. It's a very wide aspect, and we're going to be unpacking it in this class. So let's proceed right away. But before we proceed, I encourage you to subscribe to my channel and also to turn on your notification and also to like and share this video with your friends. This will help you to always get to know every time we release new videos. So let's start right away with the law that provides for manslaughter, and that is under section 187 subsection 1 of the Penal Code Act of Uganda. It provides for the offense of manslaughter, and then the punishment is under section 109 of the same law, and the punishment, of course, is life imprisonment under Ugandan law. So let's proceed very quickly to look at the ingredients of the offense of manslaughter, and these were clearly laid down in the case of Uganda versus Alijuna Matia. This is criminal case number 131 of 2011, and basically there are three ingredients of the offense of manslaughter. The first one being the death of a human being. So again, there must be a deceased party for this offense to be successful. And then secondly, unlawful causation of death. So again, the death must be caused unlawfully. Then thirdly, the participation of the accused person or persons in causing the death must always be established. And this is what we call putting the accused person on the scene of crime. Of course, these elements are a bit similar to those provided for the offense of murder. But we are going to proceed and look at the classes of manslaughter so that they can help you really to understand what manslaughter is really about. So manslaughter really has about two classes. One, the first class being what we call voluntary manslaughter, and this is where the actus reus and the mens rea of murder is present, but the accused killed under circumstances which the law regards as mitigating the gravity of the offense. So under voluntary manslaughter, and let me throw more light here because it really confuses students a lot. Under voluntary manslaughter, here both actus reus and mens rea are present. All the elements of murder are present, but the only difference is that the offense has been committed in circumstances that actually are mitigating in a way. And when we talk of these mitigating circumstances, here what we mean are the defenses that would consequentially reduce such an offense from murder to manslaughter. And these mitigating defenses include, one, the defense of infanticide. We'll be looking at defenses, and I'll help you unpack that defense of infanticide in material detail. And then the second one is what we call provocation. We'll also be looking at defenses, and I'll help you unpack the defense of provocation. The other one is what we call diminished responsibility. For purposes of provocation, for your personal research, please go and look at section 192 of the Penal Code Act, and also for the offense of infanticide, you go and look at section 213 of the Penal Code Act. And then lastly, there's another defense. I know it's not really very common, but it's also applicable, the defense of suicide pact. Again, like I said, we'll be looking at these defenses. Some of them could really be very new to you, but we'll be unpacking them in our later session. But it's important to know that if those mitigating defenses are present where there's both actus reus and mens rea, then those will act to mitigate or to reduce on the gravity of the offense from murder to manslaughter. And we just stated them quite very clearly. And that is voluntary manslaughter. And those are the parameters within which it applies. Let's now proceed to look at another class of manslaughter, and this is involuntary manslaughter. Now, for involuntary manslaughter, these are cases that are not accompanied by malice aforethought. So here there is actus reus, there is that guilty act, but what is missing is actually the guilty mind, the mens rea. And remember, like we said, as a general rule and a principle of law, is that for an offense to be complete, there must always be actus reus and mens rea, save for the exceptions under the offenses of strict liability, which is a different class of offenses. But for murder, there must always be actus reus and mens rea. For the purpose of the definition and to do your personal more research on involuntary manslaughter, I encourage you to go and read the book of Smith and Hogan, 1992, at page 3, Essentials of Criminal Law. Actually, it attempts to define involuntary manslaughter as such. So, as a bonus in today's class, I'll also help you to understand exactly what we mean when we talk about causing death. Because normally students don't appreciate the scope or how big the aspect of causing death actually is. They only look at it narrowly. So as a bonus in this video, I'm going to take you through what causing death really actually means, both under the law and in fact. Before we actually even go to unpack it, the law for that is under section 196 of the Penal Code Act of Uganda. That section actually defines in material detail what causing death actually means. And you will be really very surprised or mesmerized as to how wide the scope of causing death is. And causing death under the law includes the following. 1, infliction of bodily injury that later kills such a person after medical treatment. So let me throw more light on this. The accused is still deemed to have caused death if actually the accused inflicted injury on the deceased and the deceased actually doesn't die immediately. They proceed to go and get medical treatment. It could be even for as long as 2, 3, 4 months, or maybe even 7 months. But within that time, they actually later on die after getting that medical treatment, but from that injury that was inflicted by an accused person. So that still falls within the scope of actually causing death, and such an accused person will be said to have actually caused death. Let's proceed and look at another element that amounts to causing death, and this is if one, through threats of violence, causes another to perform an act causing them death. Very, very important. Okay, so if, assuming you threatened another person or actually caused violence on their body, and of course that violence causes that person to actually perform an act causing them death, then definitely you would also fall within the scope of causing death. Then also the other aspect that entails causing death is infliction of bodily injury that kills such a person. This is quite direct. So if you inflict bodily injury that of course later on leads to the death of such a deceased person, and rightly so, this is actually the most common scenario where you inflict injury and the other person dies. So definitely that also amounts to causing death. Then also the other one is quickening one's death, which would otherwise have happened due to disease or injury. So again, this is quite interesting. So assuming you had, let's say, a sick friend in the hospital, and then all the doctors in the world had actually confirmed or have confirmed that actually this person is going to die maybe in a week's time or in 2 weeks or maybe in the next, let's say, 6 hours. And surely there is nothing that can be done even by medical evidence. So if you still went on to kill such a person, even though they were actually going to die in a very short time, that would still amount to causing death of that person. It can never be a defense, at least not under Ugandan law, that anyway the person was still going to die. It's immaterial. Even though that person actually requested you to kill them, you would still be found within the brackets or within the walls of causing death. And this is very common with the so-called mercy killing, where the deceased, due to a lot of pain or maybe to loss of hope that they will cure, such a disease asks another person to end their life. The so-called mercy killing under Ugandan law, even if you did that, that would still amount to causing death. Then lastly, the last scope of causing death or also includes doing an act or omission which is accompanied by other acts of the deceased or other persons causing death. Very, very important. Doing an act or omission which is accompanied by other acts of the deceased or other persons causing death. So this is also very important, and it also includes causing death. So thank you very much. That was really all pertaining to manslaughter. Thank you for listening. Please do not forget to subscribe to my channel, to like and share, and also turn on your notification. We meet yet again in another class. See you. Bye-bye.